Okay, ladies and gentlemen, have patience to further view this little and simple presentation in the subject fundamentals of criminal investigation and intelligence. So the discussion in this presentation is the most important and initial issue that every student of this subject must familiarize and able to discuss the threefold aims of criminal investigation and the three eyes of uh, criminal investigation. So do not be confused. If in some references it is 4, you will see why in this video, why some are 3 and why some are 4. No? So to cut the story short, 3 and 4 they are just the same as to its content. So again, presenting to you the threefold aims of criminal investigation and the tools or 3 eyes of criminal investigation. Alright, so enjoy and be patient for you to have a little understanding about this presentation.
Okay, so my discussion for this video is to emphasize to all of you, uh, the 3 eyes or tools of criminal investigation. No, these 3 eyes, or sometimes it is 4 eyes, or tools of criminal investigation. These are the weapon, the primary weapon for every investigator, for him to be successful, for him to know and establish the identity of the guilty party, to locate the guilty party, and to provide evidence to support his guilt in the court of law. So for him to attain the threefold aims of criminal investigation, these 3 tools of criminal investigation must be always put into emphasis. So again, do not be confused why in some books or in some references there are 4, not 3. It is just the same. 3 or 4, they are just the same. Why it is 3 in other books or references? Because information and or what is being used is interrogation and not interview. Because interrogation is formal form of questioning, and interview is informal form of questioning. Informal because you can do it whenever, wherever you are, to a person or resource person, so long as they are willing to give you information. So in other words, you need not to employ techniques, you need not to employ procedures as provided by law, because this is informal. But of course, I'm not saying that interview is useless, but of course, this is also a part of the process or tool for an investigator to acquire information or evidence relevant to the investigation. But of course, when it comes to interrogation, interrogation is formal. It is formal because it is governed by law. No, it is governed by law, and it is covered by rules and regulations. Interview and interrogation are similar because they are a technique or a procedure of questioning, no, a person. But in interrogation, as I said a while ago, it is a formal, no, because interrogation also is applied when the person to be interrogated, no, or the interrogee, that is how we call the person subject for interrogation, is not so as I said a while ago, no, interrogation is formal, no, in the sense that but before that, you have to understand that the subject for interrogation are those people or person of interest of the investigation who are unwilling to give information or to answer questions asked by the investigator. No? So who are those people who are unwilling, or who are those person of interest in investigation? Number one is of course the suspect. No, there is no suspect who will just admit or give you information, that will discriminate him. No, that is why if the subject is unwilling or reluctant, then basically interrogation is much appreciated to be applied by the investigator. The very aim of interrogation is to obtain confession, no, to obtain confession from the suspect, no. But of course, witnesses also may be interrogated, as the case may be. But commonly, suspects are being the one who will be interrogated. So, how do we call the person subject for interrogation? We call him interrogee. How do we call the officer who conducts interrogation? It is the interrogee. Is it possible that the interrogee is the investigator? Of course, that is possible. No, that is possible. And how do we call the person subject for interview? Interviewee. And how do we call the person or officer who conducts interview? We call him an interviewer. No, of course, the interviewer, the interrogator, as far as criminal investigation is concerned, they are all they are the investigator of the case. No. In the PNP, how do we call the investigator? We call him as investigator on case or the duty investigator. Okay. Let us go back to the three tools of criminal investigation. No? So interview and interrogation, they are part of the tools of criminal investigation. So as I said a while ago, do not be confused. Why in some books it is 4, 3 or 4, it is just the same. No? In some books they just separated interview and interrogation. No? Then remember, as far as interrogation is concerned, it is also called formal, as I said a while ago, because it is governed by law. For example, as provided by Republic Act number 7438, that is an act or a law providing rights for persons arrested, detained, or under custodial investigation. It says under that law that as investigators, at all times, the person, in all processes of investigation, such as interrogation, he must be provided, he must be assisted by his counsel of his own choice. If he could not afford a counsel of his own choice, then as provided by law, the government must provide one for him. the investigator or the police or the NBI, of course, they have connection to the public attorney's office or the Integrated Bar of the Philippines, who could provide them free legal assistance, for persons, especially suspects, who could not provide their own counsel. Counsel is a right as provided by the Constitution for people in connection to criminal charges, for them to be protected against any abuses, and of course for them to exercise the rights for those defendants or criminals or those people charged of a crime. So, as investigator, that is the one that you will consider. As I said before, criminal investigation is bound. It is governed by laws and rules that if you will not follow them, then the result of your investigation is a failure. Because the court, if they will find that out, they will dismiss or acquit. They will acquit the suspect or accused, or they even dismiss the case. And that is a failure to everyone, especially the investigator, the organization, and of course the victim themselves. There is no more justice if that is the case. So that is how crucial investigation is. So if you are an investigator, you should have all the qualities. In your notes you have the qualities of an investigator. If you have no quality, 99% of the enumerated qualities and characteristics, then basically, aside from training, of course, before you become an investigator, there are courses that you should finish before you will become an investigator. That is why not all police officers are investigators. Not all members of the National Bureau of Investigation are investigators. They have their own functions. So of course, the next that is all about interrogation and interview. Before I proceed further, information as a tool of criminal investigation is the key tool. As I said, this is where mostly investigators are depending upon as far as Philippines is concerned. It may be painful, it may be unacceptable. In our country, forensic science is very weak. Try to observe our localities, there are crimes committed, but basically no suspect identified, because we could not process, we could not collect physical evidence properly. Even we collect physical evidence, but we have no equipment, we have no experts to process it, aside from the mishandling of evidence. And of course, you could not process an evidence if you could not identify one. And today, to identify evidence at the crime scene, for example, you need equipments. Aside from the fact that we have a weak system of storing evidence, that as we have no complete file of fingerprints, for example, for all people in this country, so that whenever there is investigation, as far as fingerprint is concerned, they can just match it with the system and identify who owns a fingerprint found at the crime scene. But that is a hope, that in the future, we will compete, the level of investigation of other countries. So in information, that is where intelligence get into. Intelligence again is a processed information. Intelligence is a verified, intelligence is an accurate, intelligence is a reliable information that is given to you or shared to you as investigator or you yourself as investigator have processed it, no? You know, the uniqueness of intelligence is that this information has been verified, no? This information has been secretly verified through surveillance and so forth and so on. So therefore, whatever the result of that intelligence, no, that you must use are reliable already, no, they were processed. But I am not saying that in the tool of investigation, intelligence is the only means or source of information. But of course, there are other uh, means to have information, such as testimony of eyewitnesses. Today we have CCTV. Because of the CCTV recording, at least you will get an information on the appearance, on the sex, and on the identity of the possible suspect. You know, that is the importance of CCTV today. Okay, so that is information. No, it is the key tool. No, key tool of investigation. And of course, the third tool of criminal investigation that an investigator may use to gather evidence, to locate, to identify, locate, and provide evidence is, of course, instrumentation. Instrumentation is where forensic science come into. No, that is where criminalistics is being used by investigators. No, but you know, in the actual scenario, it is not the investigator himself who conducts the examination of physical evidence such as blood, fingerprint, bullets found at the crime scene, cartridge cases, no, processing of DNA to identify the suspect. You know, it is not the investigator, but rather the investigator is the one who will identify, recognize, collect, and preserve the physical evidence, and he will request the experts. No, in the PNP, they request the crime laboratory of the PNP to conduct examination of evidence and to provide the result of the investigation to the investigator. So, re-requestan yan. No? So, the crime laboratory and the investigator works together, no, for the success of the investigation. So that is how investigation is done in this country. That is why, you know, if a place have no crime laboratory, you know, umaasa lang tayo sa PNP crime lab. So example, in Ifugao, we have only one crime laboratory that is located in the municipality of Lamot, Ifugao. No? So if you are from Alfonso Lista, then basically you have to travel going to crime laboratory of Lamot. No, but of course that is what is in the ground. No, so we hope and pray that in due time, no, every police station have their own crime laboratory, so that there is flexibility, and there is flexibility in the access of the investigation. Okay, so as I said a while ago, no, we hope the time will come. There will be available crime laboratory for every police station, municipal police station, so that they could be the one to process evidence that they gathered, no, during the course of their investigation, and of course equipments. So you know, that is instrumentation. You know? So when you say instrumentation, the thing that should come into your mind is forensic science. That is why, if you remember, criminal investigation is categorized as an art and as a science. No, so it is a science because criminal investigation is using inseparably what we call forensic science, criminalistics like question document examination, forensic ballistics, and so forth and so on. Okay, so that is all about instrumentation. That is all about the three tools of criminal investigation. Okay, so again, that is to stress it out. This is much repetition of my discussion. Okay, so do not forget the three tools of criminal investigation. Okay, so my next discussion to all of you, this is just a discussion of guidance. The notes is with you, and other references is with you. So use them for you to have the details of a discussion. So the next topic that I would like to introduce is, of course, as we discussed in our recent meeting, is the three, no, the three fold aims of criminal investigation. So as I said a while ago, the threefold aims of criminal investigation, these are the purpose, these are the intention, no, or this is where investigation should go, no, for an investigator to be successful in his criminal investigation. So before I would like to proceed, before I proceed, I should say, is that, if they ask you when shall criminal investigation start, kailan mo pwedeng sabihin that there is already or investigation has started already. No? So basically, just like saying when to say that a person is a father or a mother. Of course, a person is a mother when the child is already born. No, it's like when to say that there is a human life. According to the law, there is human life. No, when there is already conception in the womb of the mother, there is already life. So okay. So going back, a criminal investigation starts upon the arrival of the first responder at the crime scene. First responders are the first officers who responded at the crime scene. What is crime scene? Crime scene is where the crime has been actually committed, as I discussed before. Yeah. So upon the arrival of the first responders at the crime scene, that is the start of criminal investigation. No, but again, the first responders are not the formal and designated investigators as far as the PNP is concerned, but rather there will be an investigator of case who will come and take charge the crime scene investigation and until the end of the investigation. Okay? So as investigator, these threefold aims of criminal investigation, you must fulfill them. You must fulfill them, through your criminal investigation. So to fulfill these threefold aims of criminal investigation, you have to conduct properly your criminal investigation. So first, that you should establish as criminal investigator whenever there is a crime. When there is a crime, always the first thing that even a normal and a civilian person thinks and asks and wants an answer is the question, who committed the crime? What is the identity of the offender or culprit of the crime? So therefore, that is the first question that an investigator must answer, because if the investigator will not identify the suspect, the culprit or the offender of the crime, then basically the investigator will not proceed and have no basis to proceed in his investigation. No, you could not proceed with the next step of investigation because you do not know where to start. And if the identity of the suspect is not established, then the effect of this is whatever evidence that you gathered at the crime scene, whatever evidence, especially physical evidence that you obtain, then if the longer time that these are not being used, because there is no person for you to collaborate, no, such physical evidence, then it will be destroyed or they will deteriorate. Such like eyewitnesses. The longer the time that there is no suspect identified, then basically, no, namamatay ang tao. That is why pag namatay yung witness, nasira yung evidence because most physical evidence are biological, such as fingerprints, such as blood, and others. Pag biological yan, they will be subjected to deterioration and destruction even if you preserve them. That is why that is how the identification of the suspect of a crime is highly important. No? So, what should the investigator do to identify the suspect? No? That's why, when we do not identify, we have no any idea on the identity of the suspect. We call the suspect as at large because no identity. No, but if we have identity, no, but this person is hiding from the law, no, then we call him as fugitive, no, fugitive, takas, no. Not only that, but those escaped prisoners, they are also fugitives. The bottom line of a fugitive is you are identified as suspect, you are identified as accused, you are identified as criminal, but you are hiding from the uh, ambit, or you are hiding from the hands or long arms of the law. But at the end of the day, no one is above the law. At the end of the day, the long arms of the law will come and catch you in due time. But of course, what is ideal and proper is the shorter the time, the quick possible that the suspect is identified so that investigation will smoothly flow and justice will be served. No? Because not all suspects also are the real, no, people who committed the crime. That is why the early the better that you identify suspects, that you will collaborate evidence to see in the part of the investigator if really this person is liable, or this person is innocent in the level of the investigation, so that we will not disturb people and incriminate them, no, because it is not good, no, to file charges against an innocent person. As I said before, it is better to investigate and identify the innocence of the person rather than many convictions, many convictions. My point is, that is why on our law, no, whenever a person is charged of a crime, he is always presumed innocent until proven guilty by the court of this country. In the process of this country, even you are convicted in the lower courts, in the regional trial courts, affirmed by the Court of Appeals, still you have the Supreme Court who will say the final words and confirm if your conviction is legal or constitutional. Okay, so that is how identification of suspect is very important. No, that is why, as I said before, no, the longer the time that the suspect is not identified, no, that is leading to the crime as unsolved. No, the longer the time that investigation is conducted, but there is no suspect, there is no evidence to identify a suspect, then the case can become a cold case investigation, as the case may be. Yeah. So cold case investigation. Cold case investigation have been popularized because of the presence of technology. It's like DNA analysis. So even the suspect or the victim, for example, is buried 10 years ago, they can exhume him. That is what we call exhumation. Exhumation. exhumation and conduct DNA analysis or uh, other examination to determine the cause of death. No? Example, nilibing, akala is natural death, but after 10 years they were able to get information that there is foul play of the death for the death, then basically they can conduct a cold case investigation for that matter, or after many years of the investigation have halted, or they stop the investigation because there is no evidence found. Then after 10 years, there is an evidence that will lead to an investigation. Then basically, that is already a cold investigation. But on the other hand, if there is failure of the identity of the suspect and evidence to identify a suspect, that is leading to an unsolved crime. And you know, there are many unsolved cases in this country because of unavailability of evidence and incompetence of investigators in some areas. No, uh, you know, as I asked before, no, when shall to or when to say or when shall a crime is considered solved in the part of the investigator? So the answer is, a crime is solved or considered solved for the investigators if there is already a case, there is already a charge of crime in the court. So when a charge is filed before the court, or when an action is filed before the court, then basically the crime is solved on the part of the uh, investigator. But of course, the best way to measure that the investigation or the crime is solved is when the accused or the suspect is already convicted by final judgment. So that is as far as that issue is concerned. No? So after identifying the suspect also, that is not sufficient. No, that is not the end of the story. So even you identified him, but you have no jurisdiction over him, then basically you could not force him, you could not have a proper investigation if you have no jurisdiction over the person. So for the investigator to force or to give opportunity for the suspect identified to answer the evidence and allegation against him for the crime committed, then we should locate him. And how to locate? You have to provide evidence to convince the court that this person must be in custody so that he would answer for the crime charged against him through evidence. So therefore, in the second aim of criminal investigation, the investigator must provide evidence, gather evidence to convince the court to issue a warrant of arrest in order for them to arrest the suspect and bring him before the court for him to answer the charges against him. You know, the purpose of arrest is to give opportunity for the suspect to answer. You just imagine if we charge a person without having jurisdiction over him. No, he is there. He is there chewing mama. He is there playing basketball. No, while the case is there. So of course we arrest him. Aside from it is of course to protect him from events of the offended party. No, but the main aim of the arrest is for him to answer the charges against him and to ensure that he will attend his responsibilities whenever called for a trial or prosecution in the court of law. No, so that is the purpose of arrest. So in the second aim, you have to arrest. No, so for you to arrest, you have to locate him. No, and serve a warrant of arrest. So again, before you conduct arrest, you have to always remember the law that before you conduct a lawful arrest, you should have a valid warrant of arrest. And when to say that a warrant of arrest is valid? When the signature of the issuing judge is affixed in the warrant of arrest. But again, before you will apply for a warrant of arrest, you have to locate him. You have to conduct surveillance. You have to conduct different investigation, follow-up investigation, so that to provide more evidence for the location and to convince the court that he must be arrested. No. So after, when you are there serving a warrant of arrest, no, what is the first right as provided by law? You have to inform him of his rights, Miranda rights, or else again you will suffer technicalities when you are facing the court, witnessing in court. No, so the first right that you should inform is the right to be informed of the nature of the accusation against him. Of course, ikaw ba naman ang aarestuhin, hindi mo alam bakit ka inaaresto. No? So that is why you have to inform him of his rights, of the dialect understood by him. No? Kang English if you know that the person could not understand it. No? So, as I said a while ago, the first right is the right to be informed of the nature of the accusation against him. Inaaresto kita dahil sa paggagahasa sa aso ng ating kapitbahay mo, or panggagahasa kay Juana, or pagpatay, or pagnanakaw. So, that is how to inform of the nature. The right to remain silent, the right to have counsel, no? Those are the other rights that you should inform, and you must understand that, so that you will not be at fault at the end of the day as arresting officer. No? So, can an investigator arrest? Yes, he can arrest. Pwede ba that the investigator will not be the one to go and arrest? Yes, because it depends on who will go and arrest. No? But the investigator will be the one to take charge, and conduct interrogation and other investigative techniques towards this person arrested. No? So, as part of the rules of law, no, what shall be the responsibility of, I am just saying it in a general aspect. What is the responsibility as provided by law of the arresting officer? After the arrest, you must bring the person arrested to the nearest police station, or in the absence of a nearest police station is the jail. That is your responsibility. Ang mga dahil maganda, dalhin mo sa bahay mo or sa hotel or some hotel, that is not good, because you will be charged of arbitrary detention. No, if you are also a private citizen and you apply the citizen's arrest, you must follow the same, bring to the nearest police station, or else you will be charged of illegal detention. So illegal detention for private citizen who will incarcerate without valid ground in anywhere a person. For an offender, also for a public officer like the police, no, arbitrary detention. No, aside from other facts that when a person when you arrested a person without a warrant, you have to observe the reglementary period of detention, the 12 hours for light offense, 18 hours for less grave, and grave offense for 36 hours. For within those periods, no, whatever the case, you should process him, conduct inquest, and file the necessary charges if there are. If there are no, after inquest, there are no basis for the arrest, you have to release him. No, or else, if you will not release him and process within that period, you will be charged of arbitrary detention. If after this period, before you file the case in court, still you have a liability, failure to deliver a detained person, arrested person to proper judicial authority. No, so do not forget that those are legal issues that you should consider as far as arrest is concerned. And of course, as far as investigation is concerned, we have what we call booking procedure. We will discuss that later as part of the procedure after arrest. Booking procedures like mugshot, taking of fingerprint, medical examination, and so forth and so on. That's part of the booking procedure. No? So that is as far as arrest is concerned. The second aim, to locate and arrest the guilty party. Then of course, when there is already an arrest, that is not the end. But the investigator still will conduct investigation to gather more evidence and establish if there is a prima facie evidence. Prima facie, from the term itself, primary. Prima, primera, primary, prima facie evidence. This prima facie evidence is a convincing, an initial convincing evidence na nagtuturo sa suspect na meron siyang ginawa or connection in the commission of crime. So, if there is a prima facie evidence, no? Example, there is a CCTV, no? Na nakita yung suspect, no, galing sa crime scene, or witnesses telling that he is the one who committed it, then basically that is a prima facie evidence for the investigators to file a criminal complaint. Yan yung tawag, complaint, to the prosecutor's office. If you are in the municipality or city, you will see the prosecutor's office in the so-called provincial prosecutor's office. Andun yung tinatawag na fiscal or prosecutor. Fiscal or prosecutors, they belong to the Department of Justice. They are under that agency. Like the PNP, they are under the DILG. The NBI, they are under the Department of Justice. Okay? So upon receipt of the criminal complaint, that is not the end of the work of the investigator. The investigator will still assist the prosecutors in the conduct. Ano ang gagawin ng prosecutor? They will conduct the so-called preliminary investigation to determine and establish probable cause. Probable cause is a high standard of evidence, a high form of standard of evidence that will lead the suspect or respondent of a crime that he may be involved in the commission of the crime. In other words, ang probable cause is a high form of standards na nagtuturo that the suspect or the respondent, kasi ang tawag sa tao, subject of preliminary investigation, is respondent. Sa police, we call him a suspect. No? Pag naisampa na ang kaso sa korte, we call it an accused. No? So those are the terms that you have to understand. So, again, as I said a while ago, even the case is already in the prosecutor's office, then still the investigator will assist the prosecutor by providing necessary evidence. Okay, if the prosecutor asks you to give the sketch, crime scene photograph, and so forth and so on, then you have to provide. That is the work of the investigator. Then if there is probable cause, but if there is no probable cause, then basically on the part of the prosecutor, they will dismiss the case. Kung gusto mo ulit mag-file ng criminal case or criminal complaint, then do it. But it's, again, mahina na yan. But of course, if there is probable cause after preliminary examination by the prosecutor, assisted by the criminal investigator, then the prosecutor will draft and file a criminal information, charging a person of a crime in the proper court. So pupunta na sa korte yung kaso, and the court will receive the criminal information, raffle it, and schedule it for trial. Okay, hearing. So still, when the case is already in court, that is not the end of the work of the investigator. The investigator will still be called by the court to appear, to testify give his testimonial or testimony in the court to affirm the result of his investigation, to affirm the evidence submitted in court. So again, you will be appearing as witness, as ordinary witness or expert witness, as the case may be. The court will cross-examine the reliability, accuracy, and legality of all evidence that you have submitted in court, through the prosecution. Yan, hindi tatapos dyan ang trabaho mo. So that is why, as I always say, if you are an investigator, you have to biblically, legally, and morally do your job, so that when you are in court, the case will not be sacrificed. Because if during judgment, the court may dismiss and acquit the suspect or accused. So again, that is a failure, as I said a while ago. Okay? Yeah. So until the time that the person is convicted, then basically that's the end of the the function of the criminal investigator, and that is a success on the part of the criminal investigator. So those are the threefold aims of criminal investigation that every investigator must accomplish. Okay? So to accomplish it, use the three tools of criminal investigation. And also to accomplish this, you have to do the process. We have the phases of criminal investigation. So that's it for my discussion as far as the threefold aims and the tools of criminal investigation. Okay? For more details, you read your notes and other references. Thank you. Okay, so the last topic in this video will be the question, what is intelligence? Always remember that intelligence, you will understand it in three ways. Number one, intelligence can be understood as, of course, that is the best one. That is the primary meaning of intelligence. Intelligence is a processed information. I'm always saying this, even in my past discussions, a processed information. An information that has been verified, an information that has been information that the accuracy has been established and its reliability. So therefore, an intelligence is a very useful one, a processed information. Not unlike the testimony of people, you do not know if these are true or not. Because in intelligence, as I said a while ago, there are two ways of gathering or processing, collecting information and processing the same before it will become intelligent. Covert, secret, that is the primary tool of intelligence, gathering of information. Covert and overt, open and close. So covert is secret, then overt is open. Open, you go and secure documents, that is open. They know that you are gathering information. But in covert, it is surreptitious, it is secret. So basically, if you are watching and following a person secretly, then you will see the reality. It is real. But if you face the person and ask him, sometimes people lie. Not like when you secretly follow them, mostly it is a reality. Okay? So again, intelligence is a processed information. And information that is processed. Secondly, pag narinig niyo yung term na intelligence may refer to an agency, an institution, that is in charge in gathering information and producing intelligence. In us, as I discussed before, we have NICA, we have the CIA in America, Mossad, and so forth and so on. Those are intelligence agencies or community. Then third, intelligence may be understood as a process of gathering information secretly or openly. okay, a process. So there are three: a product, no, an agency, or a process. Those are the three considerations that you have to understand. So please read your notes as far as intelligence is concerned. No, read more details, and we will see them and discuss them later. So again, the intelligence that we use in criminal investigation is, we call it criminal intelligence or law enforcement intelligence. Okay, there are many kinds of intelligence. Military intelligence, that is not the one that they will use. No, uh, national security intelligence. No, the focus of intelligence that we are using in criminal intelligence is an intelligence relative to a crime, relative to a criminal syndicate, or any criminal related activities or law enforcement issues. Okay, so that is intelligence. No, do not forget it, and you stand by for more updates as far as the fundamentals of criminal investigation and intelligence as a subject matter is concerned. All right. Thank you.